Hey everybody, it's Joel Williams and Chase Elleby coming to you again from the Williams Elleby Studios. Today we want to talk to you about the 7 secrets to winning your injury case.
Yep.
What's secret number 1, Chase?
Know the value, right? And by that we basically mean kind of have an idea of what your case is worth. And of course, you can rely on an attorney who's been doing this for years to kind of give you an idea of what the value is. But, we kind of like to use the example, a stub toe isn't going to get you $1 million. So going in, I think, with realistic expectations of what your case is worth, which I know we've done other videos on certain factors to consider when you're trying to evaluate the case. But kind of having reasonable expectations of knowing what that's worth is, I think, a big start to getting you in the right, in the right direction to having a successful case.
Yeah, and I think that's extremely important because you need to know what a reasonable settlement value is for your case, because if that offer is made to you, you don't want to turn it down thinking that your case is worth 5 times what a reasonable settlement value is.
Right.
And so you also don't want to jump on the first offer from the insurance company thinking that, oh, my case is probably only worth that.
Right.
Because your case in all likelihood is worth a lot more than whatever their first offer is going to be.
Yep.
So it behooves you to do the research, or at least, like Chase said, consult with an attorney to try to figure out what is a case like mine worth in this jurisdiction or this place that I would have to bring the case in. So speaking of that, I think secret number 2 is to pick the right attorney.
Right.
Because I have seen way too many times where attorneys overpromise and underdeliver. I tend to be the opposite. I want to underpromise and then try to exceed those expectations. But some attorneys, not all, but some attorneys will tell you, hey, we can probably get you $100,000 or $1 million for this injury without even knowing all the facts of the case. So if that happens, if they are making big promises without knowing everything about the case, it's probably in your best interest to be wary of that person.
Right.
However, once they know about all the facts of the case, once they know about your damages, they know how badly you're hurt, they know the challenges that you're going to face, then a good attorney should be able to come up with a reasonable estimate of what your case is worth and give you that proper advice. So just make sure you're hiring the right attorney to represent you in the case.
Right, just like, you wouldn't go to a foot doctor for, a heart condition. Mm-hmm. Same thing, don't go to a bankruptcy lawyer to handle a personal injury case. Or, if you go to that bankruptcy lawyer, ask them, hey, have you handled personal injury cases before? What are your results? So being aware of that is, I think very important.
Yep.
So the third thing would be to go ahead and gather all the evidence that you need to pursue your claim. We've done plenty of videos on kind of evidence and what that is, but if it's a car wreck, it's a police report. If it's if it's a slip and fall, it could be a video, it could be witness contact information, all that stuff you need to kind of have to pursue your case. Go ahead and gather as much of it as you can on the front end.
Yeah, and heck, it could be a video for a car wreck case.
Right.
I mean, just today we were speaking with a lady whose wreck was videoed from a Crystal restaurant at the intersection. Mm-hmm. And their camera caught the entire thing, so we could see what color the lights were, whether they were red, yellow, green, and all that kind of stuff. But you can rest assured that the insurance company is going to gather all of that information and all of that evidence, so it's in your best interest to go ahead and gather it yourself as well, so they can't misrepresent to you what it is. And when you make a demand to the insurance company, if you have all of your ducks in a row and you have all of this information, they understand, hey, this person's prepared. This person's going to be a force to be reckoned with, so we need to take their claim seriously.
Yeah, and it makes their job easier.
It does. It does.
I mean, if you're
asking somebody to pay you a bunch of money, it's actually, at least at a certain point of negotiations, in your best interest to make their job, make their task of paying you that money easier.
Yep, exactly.
And that involves getting all the evidence and giving it to them. Also, secret number 4 is similar but not the same, but it's contact all witnesses for whatever the event was. If it's a fall, if it's a car wreck, whatever it happens to be, make sure you know who the witnesses are, make sure you contact them and hear what they have to say, because that goes into knowing what a reasonable value for your case is going to be. Mm-hmm. And if you have these witnesses on your side and you can get statements from them pre-suit and you send that to the insurance company, that lets them know, hey, this person's taking this case seriously.
Yeah, exactly. I've had cases where I've told the insurance company, hey, here's, John Doe's number. Go ahead and give them a call and talk to them. They saw the whole thing, and then they'll do it, and they'll call me back and be like, yeah, talk to so-and-so. We're accepting all liability, so it definitely helps. Absolutely.
Yep. And if you're in litigation, hopefully if you're in litigation, you've got an attorney. But your attorney should be contacting these witnesses and sometimes taking their depositions if necessary.
Yeah,
So
absolutely.
what's secret number 5?
So number 5 kind of transitions into the treatment portion of the injury, right? We're personal injury lawyers, so there's always an injury that follows. It's just stay consistent with that treatment, right? Whatever the doctors tell you to do, just do it, right? Just do it till you get better or till you're as good as you're going to get. If you start having big gaps in treatment or missing appointments and things like that, it just gives the insurance company ammunition to say, well, yeah, you may have been hurt or you weren't hurt, and we know you weren't hurt because you stopped going to treatment or you have a huge gap. Or the wreck happened and then 3 months later you finally go see a doctor, right? Anything that they can argue that we're not responsible or you're not that badly injured, they're going to argue, right? So if you take a long time to go to the doctor after a wreck, they're going to say, well, the wreck couldn't have caused those injuries because you didn't go to the doctor right away, right? Or if you go to the doctor and they say go to physical therapy, you need to do 3 visits for 6 weeks and you only do 2 weeks of treatment, they're going to say, well, yeah, you might have been hurt, but you weren't that badly hurt because you stopped going. Or they'll say,
You're all better.
Yeah, you're all better. Or if you're saying you're not better, that's on you because you didn't do what you were supposed to do, right? It's called mitigating your damages, right? So if the doctor says go to the physical therapist, go for X amount of days and you don't go, but you're still complaining that you're hurt, can't recover for that because you still need to go to the doctor and do what they told you to do. I shouldn't say you can't recover, but they're going to make the argument that you didn't mitigate your damages. You didn't do what you were told to do.
Yeah, it's
so
going to be
very
hard
important
to recover.
Yeah, exactly.
I'd say secret 5 subsection A is if you have pre-existing injuries or pre-existing issues. So, say you went to the chiropractor for your neck pain 5 years ago, or you went to an ortho because your shoulder was hurting. When you re-aggravated or re-injured that part of your body, it's almost always going to be in your best interest to go to that same doctor if you can, because that doctor is going to be the best person to compare how you were before and how you were after. Because in most states, every state that I know of, you can recover for an aggravation of a pre-existing condition. So if you've got some arthritis or you've got prior treatment to an area of your body, if you get in a wreck, if you have trauma that makes it worse, you can recover for the worsening of whatever's there. So if your pain's at a level 1 and then you get in a wreck and your pain's at a level 8 for 6 months, then you can recover for that pain that's at a level 8 during the time that you're experiencing it. So, think about going to see the same provider that treated you prior to the incident.
Yeah, exactly. I've had a case where my client was literally leaving physical therapy from a pre-existing condition and got in a car wreck, went back to that same physical therapist and was able to document very well the increase in pain, the limitations that they were now suffering since that wreck. So it was super helpful to kind of stick with the same provider. So number 6.
Know the evidence rules.
Yep.
Because not everything comes into evidence at trial. So I'm dealing with this right now in a different case, but the defense thinks they have me because they've got this evidence, but they haven't analyzed whether it's even going to be admissible at trial. I'm not worried about it. I know it's not going to be admissible at trial. So just because you have documents and things or you have statements from people doesn't mean it's going to be admissible. So you can't, for example, we have an evidence rule called the hearsay rule, which means that I can't get on the stand and say, well, Chase told me this. There are exceptions, but in most cases, something as simple as that, I can't do that. I have to bring Chase to trial to testify as to what he actually knows. I can't testify as to what somebody else knows.
Another good example that comes up all the time is that, well, the doctor said the next thing should have been X, or I needed to have surgery.
Yep.
That always gets objected to on the hearsay rule.
That's right. So you got to know, even if you have all the documents, even if you have all the witnesses, you have to know how to get that evidence into the record at trial, because if it doesn't come in, it's useless.
Yeah, exactly. And that goes back to evaluating the case as well. You know what evidence is good, what evidence is bad. So that certainly helps in evaluating and in winning.
Yep.
So I think last but not least, number 7 would be just to be honest and be yourself, right?
Yeah.
People can sniff that out from the very beginning, whether you're taking a deposition with opposing counsel, meeting with me or Joel from the beginning to go over your case. we know right away to cut through the BS, for lack of a better term. And the jury's going to know it too. If you get up there and you squirm and you're not honest, you're not truthful, your case is done, right? So, and like I said, when we meet with folks, it very, very rarely happens, but you can kind of tell, okay, this person has a serious credibility issue, so you need to know that up front, and it's going to have an impact on the value of your case and whether or not you're going to win the case.
Yeah. The most important witness at any trial for personal injury is the plaintiff.
Yeah.
Meaning the person that's injured that's bringing the claim. If that person's credibility is called into question, it's really tough to succeed at that point. So every case is going to have issues. No case is perfect. At least no case that gets to trial is perfect.
Right.
Because if it's a perfect case, then you're going to get paid in settlement. But the key is when there are bad facts or there are challenges in the case, you have to be honest about it. You have to embrace it. And you have to do the best you can with it. And be yourself. Because if you come into a trial or in a deposition and try to pretend to be somebody that you're not, chances are you're not going to be likable. Chances are somebody's going to have a hard time empathizing with your position, and they're going to have a hard time finding in your favor. So just be yourself, be honest, and you'll have a much better chance of winning your case.
Yep.
All right, well, I think that wraps it up for the 7 secrets to winning your injury case. If this video has been helpful to you, please give us a thumbs up or hit that subscribe button. Otherwise, we will see you next week to answer the unbiased question of, do I even need to hire a lawyer?